Hi, I am Sathish Balasunderam. I'm an Ontario lawyer who practices in wills and estates and other areas. For even the average Canadian, estate planning is an important consideration, yet it is too often overlooked. Many people neglect to create a valid will, and even fewer turn their minds to powers of attorney. This video will address some of the important points to consider when contemplating your estate planning needs. I know it's boring, but it is important. Estate planning involves arranging for certain things to occur after you die. Primarily, it involves your giving detailed directions as to the arrangements that you want made, which usually includes transferring your assets, meaning your property and money, to specified family members, friends, and charities, and minimizing your income and estate tax post-death. It may also involve your planning for the possibility that you might become incapacitated during your lifetime and thus unable to make decisions on your behalf. A will and a power of attorney are two of the more common tools used as part of this kind of estate planning. Your estate is the property that you own or have a legal interest in, and in common parlance describes the assets and liabilities that you leave after you die. Your will is a written document that sets out your wishes about how your estate should be taken care of and distributed after your death. It takes effect only once you die. If you have created a will, as I have suggested you should, then your estate needs to apply for what used to be known as probate, but which in Ontario is now given the more cumbersome title of a certificate of appointment of estate trustee with a will. If you have not created a will, then your estate needs to apply for what used to be called administration, but now in Ontario is called certificate of appointment of estate trustee without a will. As I mentioned, a will is a legal document that sets out your express and specific wishes on how your property will be distributed after you die. Typically, a valid will is prepared with the assistance of a lawyer. In Ontario, to be valid, your will must conform to certain legal requirements. It must, 1, be in writing and signed by you, and 2, be signed by 2 people who do not stand to benefit under your will. In some cases, a will that has been handwritten, meaning not typed or created on a word processor, and has been signed only by you can be valid, but again, that is in some very narrow circumstances. However, the ideal situation is to have a properly drafted will, typed and executed properly. A power of attorney is a legal document giving someone else the right to act on your behalf while you're still alive. It ceases to be effective upon your death. It is different from a will, which directs the manner of distributing your assets after you die. In Ontario, a power of attorney document must comply with certain format requirements, but does not otherwise have to be registered with the government. There are 3 main kinds. Continuing power of attorney for property, which covers your financial matters. It gives the person you appoint the responsibility to act for you, even in a situation where you have become mentally incapable of managing your own affairs. Power of attorney for property, which has a more limited scope since it is no longer valid if you become mentally incapable. These are used in narrow circumstances, for example, where you have to travel and need someone to look after your financial affairs while you're gone. Power of attorney for personal care, which gives the person you appoint the right to make personal and care-related decisions for you, including decisions about your housing and health care. Although there is no legal requirement in Ontario for you to have a power of attorney, it is a good idea. And note that the term attorney in this context does not mean a lawyer. It simply refers to the person you appoint to make decisions on your behalf and to act on your behalf. As with wills, a valid power of attorney must conform to a certain format. Among other things, it must be signed by 2 eligible witnesses, neither of whom can be your spouse or children. A living will is a document that expresses your wishes for your healthcare treatment or relating to your personal care. It embodies your wishes in the event you become ill and incapable of conveying them yourself. Unlike a power of attorney, which is a legal document, a living will is merely a statement of your wishes. It does not name or appoint any particular individual and does not confer authority on anyone particular. This short video has merely touched on some of the methods by which you can achieve good estate planning, both after you die and also if you have become incapacitated or cannot otherwise make legal and financial decisions on your own behalf. Needless to say, this is a very complex area of the law. If you don't take steps to obtain accurate legal advice, you run the risk of not having your true wishes realized. Please feel free to contact me if you have further questions.